punishable under section 380 IPC and 511 IPC and passed an order of sentence as under pencil mark hakidini madam. Next para. Being aggrieved by the same during the pendency of the trial, accused number 2 died. First, therefore, accused number 1 and 3 after hearing the parties and but accused number 1 and 2 were 1 and 3 were convicted and 2 died and yes. Next, being aggrieved by the same, accused number 1 and 3 filed a ಇಲ್ಲ ರೀ ಅಪೀಲ್ ನಲ್ಲಿ ಸತ್ತೋಗಿರೋದವನು ಇವರೇ ಅಪೀಲ್ ನಲ್ಲಿ ಸತ್ತೋಗಿರೋದು ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದಿ ಅಪೀಲ್ ನಲ್ಲಿ ಸತ್ತೋಗಿರೋದು 3 ಜನಕ್ಕೆ ಅಲ್ಲೇ ಆಗಿದೆ ಅಷ್ಟೇ ಸರಿಯಾಗಿದೆ ಬಿಡಮ್ಮ ನೀವು ಕರೆಕ್ಟಾಗಿ ಹೇಳ್ಬೇಕು ಉಮಾಶಂಕರ್ ಈ ಡೈಡ್ ವೆನ್ ದಿ ಅಪೀಲ್ ವಾಸ್ ಪೆಂಡಿಂಗ್ ನಾಟ್ ವೆನ್ ದಿ ಟ್ರಯಲ್ ನೆಕ್ಸ್ಟ್ ಪರ ಆಯ್ತಾ ಬೀಯಿಂಗ್ ಅಗ್ರೀವ್ಡ್ ಬೈ ದಿ ಸೇಮ್ ಅಕ್ಯೂಸ್ಡ್ ಪ್ರಿಫರ್ಡ್ an appeal before the district court Davangere in criminal appeal number 88/2015. Next para. Learned judge in the first appellate court after securing the records, heard the parties in detail and noted the death of the second accused and confirmed the judgment of conviction and order of sentence passed by the trial magistrate by dismissing the appeal of the accused persons by judgment dated 23rd October 2020. Next para. Thereafter, accused number 1 and 3 are before this court in this revision. First, next para. Shri Maheshaya Rudraya Hirematat, Lord Counsel for the revision petitioner, reiterating the grounds urged in the revision petition, contended that material evidence placed on record is hardly sufficient to record an order of conviction for the offence under section 380, read with section 511 IPC, and therefore sought for allowing the revision petition. He also pointed out that the samples said to have been drawn from the seized paddy bags are freely available commodity in any agriculturist house, and therefore in the absence of the samples being tallied with the original paddy bags said to have been seized by the prosecution and produced before the court, there was no possibility of recording an order of conviction under section 380 IPC, and the alleged attempt of theft again on 4/9/2013 is not established by placing any cogent evidence on record, and oral evidence of CW 1 and 4 are nothing but self-serving testimony, and therefore sought for allowing the revision petition. ಇನ್ನೇನಾರು ಹೇಳಕ್ಕಿದ್ಯಾ ನಿಮ್ಗೆ? On the question of conviction ಇನ್ನೇನಾರು ಹೇಳಕ್ಕಿದ್ಯಾ?
Therefore
ಕನ್ವಿಕ್ಷನ್ ಮೇಲೆ ಏನಾದ್ರು ಪಾಯಿಂಟ್ ಹೇಳಕ್ಕಿದ್ಯಪ್ಪ? 2 ಪಾಯಿಂಟ್ ಹೇಳಿದ್ರಿ, ಒಂದು ಸ್ಯಾಂಪಲ್ ಮ್ಯಾಚ್ ಆಗ್ಲಿಲ್ಲ, ಎರಡನೇದು ಪ್ರೂಫ್ ಇಲ್ಲ ಅಂತ. ಮೂರನೇದು ಏನಾರು ಹೇಳಕ್ಕಿದ್ಯಾ?
ಹಾಸ್ಟೈಲ್ ವಿಟ್ನೆಸ್.
ಯಾರು ಹಾಸ್ಟೈಲ್?
ಮಹಜರ್
ಯಾರು?
PW7.
He also pointed out that PW7, an independent witness, having turned hostile to the case of the prosecution, a serious doubt has been created in case of the prosecution, and that was sufficient, and there was sufficient dent in the case of the prosecution, so as to believe the prosecution version and sought for allowing the revision. Innu enaru helakidya? Ashte tane. Next para. Alternatively, he contended that in the event of this court maintaining the conviction, taking note of the fact that accused number 1 and 3 are poor people and are now eking out, eking out their livelihood by doing coolie, court may consider the period of imprisonment already considering the custody period as period of imprisonment, and allow them to pay the fine of rupees 1,000 for offence under section 380 and 511 IPC, and they may be released. First, next para. Per contra, learned HCGP supports the impugned judgments by contending that the seizure Mahazar wide exhibit P2 stands established by placing necessary evidence on record. He points out that why would the police implant 20 bags of paddy for the sake of obtaining an order of conviction against the revision petitioner in the absence of any previous enmity and animosity, and therefore case of the prosecution stands established. First, he further pointed out, drawing of the sample from each of the bag is found from the seizure Mahajar itself, and the same is produced before the court as the paddy was a fast decaying substance was entrusted to the interim custody of the complainant during the trial, and therefore non-production of the entire 20 bags of paddy stolen by the accused persons did not cause any serious dent in the case of the prosecution. First, he also pointed out that the theft committed by accused persons came to the light when they again attempted to steal the paddy bags on 4/9/2013. First, when they again visited the cattle shed of the complainant, for stealing the remaining bags of the paddy, they were apprehended by CW 1 and 4, but the accused were successful in escaping from the clutches of the CW 1 and 4, and therefore, the prosecution version is properly established by placing cogent and convincing evidence on record. First, he also pointed out, next para, he also pointed out that based on the complaint lodged by the complainant on 4/9/2013, on 5/9/2013 itself, the accused persons were arrested, and based on the information given by them, paddy bags were seized, and Caesar Mahajar witnesses have supported the case of the prosecution. First, he further contended that mere PW7 turning hostile to the case of the prosecution has not weakened the case of the prosecution to such an extent so as to disbelieve the whole of the prosecution story as false and sought for dismissal of the revision petition. Next para, insofar as the alternate submission made by the counsel for revision petitioner, learned counsel for the learned HGP submitted that in a matter of this nature, showing any mercy would send a wrong message to the society, and therefore no mercy can be shown to the revision petitioner. First, he also pointed out that the accused persons are also facing similar case. Connection ಆಯ್ತಾ ಇನ್ನೊಂದು ಭತ್ತ ಕದ್ದಿದ್ದು ಅಥವಾ ನಡೀತಾ ಇದೆಯಾ?
ಇನ್ನು ಇನ್ಫಾರ್ಮೇಶನ್ ಇಲ್ಲ ಟ್ರಯಲ್
ಇನ್ಫಾರ್ಮೇಶನ್ ತಿಳ್ಕೊಳ್ಬೇಕಲ್ಲ ನೀವು.
ಅಲ್ಲಿ ಭತ್ತ ಕತ್ತಿದ್ದಲ್ಲ.
Also pointed out that there is one more criminal case on the similar charges against the accused persons, and therefore they are habituals and no mercy can be shown for such people. Next para. Having heard the parties in detail, this court perused the material on record meticulously. On such perusal, following points would arise for consideration. Whether the prosecution has successfully established the offences alleged against the accused under section 380 and 511 IPC. First, whether the impugned judgment is suffering from legal infirmity and perversity and thus calls for interference. Muru, whether the sentence is excessive. Next para. In the case on hand, the prosecution story reveals that the complainant noticed that between 7 p.m. and between 7 p.m. of 1/9, 7:30 p.m. and 6 a.m. of 1/9/2013 to 2/9/2013, complainant noticed missing of 20 bags of paddy from his cattle shed. First, again on 4/9/2013, they were able